Okay. Good afternoon, everyone. My name is Christine Bactor. I'm the Deputy Director with New Jersey's Ombudsman for individuals with intellectual or developmental disabilities and their families. And I will be walking us through the next part of our blueprint, which is around family member and guardian roles and responsibilities and needed reforms. Um, so if you're just joining us for this session, we're going to have a free-flowing conversation like we've been having all day. If you'd like to make a comment, please feel free to either raise your hand using the React tool, give us a wave. You can also drop a comment in the chat or the Q&A. So, and again, some of you may not know me. Everyone is familiar with my boss, Paul Aronson. But in addition to my role in the office as the deputy director, we're an office led by lived experience. Many of you know that Paul is a sibling. For those of you who maybe don't know me, I'm the mother of a 27-year-old on the spectrum receiving services through DDD. And I'm also his legal guardian. So I bring that lived experience and perspective to the work I do. So just taking a look at the blueprint, we have the roles and responsibilities of family members and guardians, to serve as a caregiver, to serve as a guardian or power of attorney, and to really be a primary member of the team, which is certainly a theme that has been touched upon in some of the previous sessions. And some of the needed reforms that this process has identified is inclusion of the family members and guardians in provider agency decision-making, connection with other families and guardians, education on federal and state policies, the prevention of retaliatory practices by provider agencies, transparency and access to information about their loved one, and involvement in state monitoring, inspections, and investigations. So with that, we'll open it up for conversation and comment. I see Paula Solomon.
Is there a certain amount of meetings that there is supposed to be throughout a year that the agency, the provider, is supposed to have with parents? I don't remember. I recall something like every 3 months or so, there's supposed to be a parent meeting. Is this something I just made up or heard or um
Uh, I know certainly support coordination, the support coordinator has a duty and a responsibility to be checking in with the individual or the family member monthly. There should be quarterly face-to-face and at least one visit in the home a year.
Yeah, I'm not talking about the support coordinator. I'm talking about the agency or the place where my daughter lives, the provider. Are they obligated to meet with families to give them updates on a regular basis? Or is it just whenever they feel like having a parent meeting, they can have one? But where Sydney lives, the last meeting they just had was basically to go over their code of conduct that they want the parents to follow. Um, they had a lot of rules, and they also emphasized a chain of command. And basically, in the end, told us that unless we are filing a grievance, we should not reach out to the CEO. So, is there some kind of regulation that they should be meeting with the parents every so often to provide us with what is going on at the agency, what they're doing, possibly bringing us up and educating us on some policies of the state?
That's a good question. I'm not aware of that as a mandated requirement. If anyone else on the team has a different thought about that, please feel free to hop in.
I'll just add that similarly to Christine, you already mentioned the requirement for support coordinator meeting quarterly for licensed residential settings. Those that also applies, and you can certainly request to be part of and included in that quarterly meeting with the support coordinator and the agency, whether it be the residential agency or at the day program. Um, that is a an option of yours to be part of that meeting.
Mhm.
It doesn't, I know lots of times from what I've been told, um, the agencies just want a very quick meeting with the support coordinator for that quarterly meeting, because they have a lot of folks and they don't have a lot of time. But that is certainly something that you can request a more formal, specific meeting at the home or at your home for that quarterly meeting, Paula.
I'm talking about a general parental, like all the parents whose children live in the facility to,
So that's going to be provider specific. So the providers will set the pace as to what they do.
Mhm.
There is an aspect of the Stephen Caminos law that requires that the agency provide families contact information for other families living there, and then families can decide if they want to meet
Right.
more formally, but all the families have to agree to have their name included in that distribution. If there's anybody else, I don't have the chat open. I see a lot of chat, but if anybody else, Paul or Dottie, Kathy, want to comment on that.
As long as I'm on, I'm also wondering, can you send the links to a number of a lot of the information that you providing about where to look for like this new um
The policy and procedure manuals.
yes.
Yeah. So we will, I see some people said they don't have access to the chat because they signed out and then they signed back in and the chat's, reset. We will make sure that all the resources that are in the chat get communicated out to everyone. And those manual updates will be part of that, Paula. Um, that's going to be a tall order for my team, Carrie and Kyoko, but I know that they will do their best to pull it all together. And thank you for participating and give you all the resources that were captured today.
Thank you.
You're welcome.
And Kathy Freeman, I see you have your hand raised.
Yeah, I can piggyback on what Paul is saying and being somewhat familiar with the agency that from which her daughter came, and we do have quarterly parent meetings. But I guess what she's getting at is I believe there's no requirement that a provider needs to do that. But along the same lines as what Paula is, Christine, I'd like to make you aware that these consents, these annual consents are now uh, obviously addressing code of conduct with parents. Well, and of course, I think all of us would sign off on being respectful and polite and that type of thing. But it's getting deeper than that, where we have to sign off that we follow a certain chain of command when we have a concern, that the expectation is that we do not ever go above the group home manager, and that the group home manager then moves it up the chain of command if it's not resolved. Well, it's in direct conflict with, language that's in communication from CEOs and administration, how open door they are and how we can contact them at any time. But these types of things actually in there, as what I keep saying, is also criteria for discharge. If your constant frivolous complaints are unfounded, well, yeah, and that is at the total decision of the provider. So I'm really concerned, again, with this new provider to thing that, particularly for parents who are very involved, who obviously would express concerns. But it also, in a way, limits our ability to document that these things are going on, since we're not, they don't want us to email. They bring the concern, to someone higher. So I do really have concerns of our rights as guardians, particularly since my son's nonverbal, and it becomes, I think, a real problem for us parents who have a nonverbal child who we have to speak for them. So everything that there's not a blanket on the bed, or there's, he can't tell me if he received a shower last night, and we express these concerns that it may sound constant to a provider, unfortunately, but for as we feel, we are their legal guardian, we are their voice. So we shouldn't be punished for having maybe more concerns. And also, too, that they don't put it in the consents that we have to sign off on, that we agree to their grievance policy, meaning that we can't go higher, is what they're trying to do. Again, and also causing all this frustration or whatever in parents. Is it really the subconscious will that we go elsewhere? So, and to me, when you think about retaliation, it happens in many different ways.
Thank you. I think you've raised some really interesting and important points on this topic. Certainly, I know as someone who has signed off on forms too, some of the challenges can be just around the sheer volume of forms. So I think that
many parents don't read it. And honestly,
right.
if they don't want to have to find a new place or are unwilling to bring them back home, what choice do you, I mean, I guess they just sign it. But when it gets to where they're violating civil and human rights and HIPAA laws, I think the state needs to step in. And like I said, the state has told me they do not regulate this aspect of provider care, that they follow state and federal laws, which I think is why we're in the mess we're in.
Thank you. I think Dottie, you're next.
Yeah, I think Kathy just said what I was going to say, that we really do need the state to either invest in best practices or something more intrusive, and have in I guess it's the PPMU, the sub-department under OPIA, who oversees the provider policy and procedures manuals that each provider adopts, but put in there specific language that talks about what the basic grievance policies should look like, and basic requirements for sharing information to each of the families that are in the house. I just can't see how there's any possibility of uniform rights or services without someone defining what that is, what those basic services and rights are.
Yeah, I think it's a good point that you've raised the role of PPMU in this dialogue. And certainly when those questions have come to our office, we understand that that's the review unit for provider policies as well. So I think your suggestion about what a uniform policy should look like is a good one. Thank you. And I think next we have Pat Miller.
Hi, thanks. I agree with what everyone just said. I mean, I think when it comes to family members and guardians and providers, there just needs to be a huge culture shift, right? I mean, there's this us, them mentality. And if we don't fix that root cause of that, it's just all of this stuff just gets worse rather than better. And we are their greatest asset, right? I mean, we know our child, especially ours who are nonverbal, we could provide so much pertinent information that is getting lost when they're just not allowing this collaboration to happen. And so I would love to see some sort of meeting that happens quarterly with the provider staff, especially if our kids are in a group home and are nonverbal. And families can waive that right if they don't want it. For families who feel like it's really necessary, it does so many things. It builds trust. It enables, that conversation to be ongoing. And so that it's not going to be in a time of crisis that you're meeting only and getting agitated and escalating and needing to escalate. I just feel like that proactive, again, going back to the preventative and proactive approach versus the reactive and, horrible incident approach, is where I think we need to start shifting that culture. And, again, if we lean on those good providers that we feel like are doing a good job, that's what they have. They're constantly talking to the parents. And, my friends who's in one of these great providers, like she'll call them and they were away and they answered her when they were internationally because they wanted to make sure everything was okay. Like that builds trust, that you're not going to be looking at around, over your shoulder every second thinking, oh my God, something terrible is happening there. And so I really do think those ongoing meetings that are maybe facilitated by some sort of coach that helps that process builds from the very get-go versus to the point of no return.
Thank you, Pat. And next is Kate DeLuca.
Hi, I have 3 points that I wanted to bring up about this. The first is which I would add potentially to roles and responsibilities, fiscal intermediary, because there also is a financial component that family members do need to be responsible for when they are serving as fiscal intermediary. In terms of comments on reforms, this may be a little bit too specific, but I do feel that there are times when it may be beneficial to have cross-reporting mechanisms available. And I understand that's a little bit of a slippery slope kind of thing. And what I mean by that is for guardians who are involved and who are visiting frequently, if they're noticing neglect or issues with other clients in the home, for example, or et cetera, that there's essentially a mechanism to allow us to alert somebody, like if they may not have active families, but just something like when there is kind of an outside person present, to kind of notify that way. Another item I wanted to bring up is I don't know if it would be more of a best practice versus advisable to have it as a requirement, but a provider policy handbook that is available and immediately accessible to families. I know that there are policy handbooks from what I've read of the licensure regulations, but those are not distributed out to families as a matter of course. It's kind of bare bones that, the Client Bill of Rights is something that we receive, like HIPAA policies, like grievance policies, those are all elements, but just knowing expectations for how the agency operates. Like a small example I wanted to give, we found out that the current agency will not discharge anyone from a hospital if it's after 4 p.m. or on the weekends. And we literally found this out as we were getting ready to discharge someone. So knowing that ahead of time would have been useful, but it also kind of, I think, too, if we can see what agencies are expecting of us going into it, there may be a lot less miscommunication because like we know kind of what framework they're operating in. And the last thing that I don't have lived experience in providing uh, feedback on, but something I am noticing when we're talking about the role of family members and guardians, it's all from the perspective of families and very involved guardians, but there are people that have maybe state appointed guardians. So I think that we should also just incorporate, and I don't like this isn't my situation, but it just seems as though, okay, like maybe we should reach out to that population, find out what they need, like what their barriers are, like, how many people are they overseeing? But that's another element for people who don't necessarily have families who are involved.
I think that's a really excellent point. I know it's something that we've discussed here within our office, in the Ombudsman's office, raising the question of state guardianship, and those are excellent points. I think that so many of us here are really driven to do the right thing, but if you have a multiple caseload of people that you are serving as guardian for in a different capacity, I think it can be really challenging to, determine who those people are and really kind of measure the quality of those guardianship services that are being provided. I want to move on next to Lisa.
Hi. I just wanted to say that I would like to see some reforms or improvements in terms of those who have developmental or intellectual disability, but also have complex medical conditions and medical comorbidities. Like, I don't feel like there's really enough attention paid to that. And I think that especially for those who are very medically fragile and have developmental disability going, forward into like a group home setting or they're in a residential setting, it could be very difficult for them. And I think that that there has to be things that sort of reflect that and sort of look at, sometimes they don't look at things really at a person level. Like it looks at, they look at everybody as a group, and everybody has such individual things that they can have a comorbidity or a behavior or so forth. And I really feel like that really needs to be reflected in whatever reforms are made. Not that.
Thank you. I really appreciate that. We have had a lot of spotlight today on behavioral acuity. I know in our office, we deal a lot with individuals and families who do have that behavioral acuity, but we also see some of the same gaps with medical complexity as well. And, really a lack of appropriate housing options with the level of nursing supervision, professional supervision. So I appreciate that comment. Thank you. And then coming back to Kathy Freeman.
Hi, Christine, you mentioned PPMU, and again, when I was talking about signing off on laws or signing off on consents that they don't necessarily follow laws of federal and state, but the PPMU, I don't think, is always aware of laws. I'll give an example. Several years ago, I called them because the agency my son is in restricted my visitation from 3 to 6:30. This was pre-COVID. And I met with, I did what I needed to do internally in meeting, but I wasn't getting any support there. When it's clearly a federal law based on the tenant with group homes that they can have visitors at any time. And so PPMU called me back and they said, "Oh, Mrs. Freeman, I talked to the head of residential, and the boys are getting ready for bed, and we're talking like after 6:30. I mean, they're in their 30s. So yeah, they may be, but the point was they were trying to dismiss my concern, which was a federal law. Now, of course, it took several years, and Paul's aware of this because I did go to Jonathan eventually, and then it took a while, and then all this communication came out from his office about you cannot, they can visit anytime. So when it's a federal law, I just feel, is there federal complaint that the state, like what? There can't, PPMU cannot encourage that. And they're the state entity that's supposed to help us with conflict with a provider. Just for an example, what do we do when the states, when PPMU, DDD says, well, we're not responsible for them following laws?
So I think you're identifying a potential gap in information, and I think it's something that we can definitely explore a little bit more and add this, topic to necessary reforms if there seems to be a conflict of the way the state might be interpreting something that has come down federally.
Well, and state laws as well. So thank you so much.
Thank you. Uh, and next we have Mike Sullivan.
Yeah, hi. As I said before when I spoke, my son is in a group home for 2 years, and I do try to read everything about what guardian rights are and everything, but oftentimes it's like the reality doesn't match with my understanding of the rules. And I'm talking about we had a couple incidences, and I wonder if agencies overuse non-reportable incidences and somehow get away with it. So the first incident, that seems to me more dramatic or more accurately would have been reportable. The pharmacy made a mistake and took off one of his prescriptions. It's over the counter. It's Miralax, but it's important for his person. And he wasn't taking it for 6 months, and we only discovered it by accident. And they filed a UIR, and basically DDD or the agency said it was non-reportable. And like, it makes no sense to me. So part of my question with this and the other example is there needs to be more clarity in what the guardian rights are. I just read it, and one of the support coordinators manager, who is, I assume, is pretty experienced, explained to me non-reportable means they don't have to notify the guardians. So there was another incident where he had a cut on his toe, the same one I talked about last couple sessions, and they didn't report it to us. And their explanation was it's non-reportable. They didn't notify us. So I look at the charts, on what's reportable, what's not reportable, and I'm pretty highly educated, and I don't understand the rules. And then what baffles me is he had a cut on his toe. It was June 29th. He has some other foot problems, so we went to see a podiatrist, and he said, well, sometime in the past he broke his toe. It could have been that incident. It could have been incident years ago. And so I don't know, but they say it's non-reportable. And according to the support coordinator agency, they don't have to tell us. So how can a staff person or an agency make a judgment about a first aid injury, whether or not a bone was broken or something? I don't see how these people can make that kind of judgment. They're not nurses. They're not EMTs. They don't have those qualifications. So I guess my issue is kind of three parts. The rules are not clear enough for guardians. I think the agencies overuse non-reportable, and I don't see how DDD agrees not getting a prescription is non-reportable. That makes absolutely no sense to me. So that's my issue.
I appreciate that, Mike. Thank you. I know
So,
having
Christine,
tried.
could you explain, is a first aid injury non-reportable and the guardians don't have to be notified?
So I'm certainly not expert on the charts that you're referring to with OPIA. I mean, I have also, in the capacity of my role here, along with our team, we've spent several, hours kind of as, individuals and families bring issues to our attention. We'll look at those and try to determine if an issue is reportable, but we're also able to, seek clarity from DDD about the reportability of some of that. And the other issue that we always raise is we always remind people that if they have any concern, there is a reporting line, and you as the guardian or the parent can report a concern as well.
Yeah.
And,
well, I'll probably call your office. I'd like to understand the rules, and if
right.
the agency is not following them.
And I know we had communicated via email a while ago, so feel free to circle back with me with that email chain, and we can get something
I see
going.
the comments people are making, and I read all those, but it's neither the agency or nor the support coordinator agency seem to think it's a notification to a guardian is necessary. So I don't understand how all these people in the industry seem to think a guardian doesn't have to be notified. So,
Mike, I know you're reading the chat as well, but somebody did write about, making it a requirement in the ISP that families notified, even if it's not a reportable incident. I think that could be a good place to start. I'm not
okay,
saying
yeah, yeah,
because then it's in writing that you want to be notified when there's a scratch, when there's
that
anything
makes,
that requires,
yeah.
an assessment of injury.
Yeah, I mean, I hear people mentioning Camino's law, and I guess maybe it didn't make it to the DDD rules and clarity enough that either the agencies don't understand it or I don't understand it, because it seems like it doesn't cover injury for every type. I even quoted, I found there's a circulation letter number 14 that seems like it clearly says that, and I sent that to my support coordinator, and the way she read it was only if only if it's abuse, neglect, et cetera, then it would be reported. So if he gets a scratch because somebody else did it, then it'd be reported. If he got a scratch on a piece of furniture, then it wouldn't be reportable. So,
But I'm going to interject again, Mike. But reporting it as an unusual incident should not be the same as communicating with a guardian or family that
correct,
is asking for communication that goes separate and apart from the unusual incident.
right,
So while Camino's law, spells out some specifics that are still probably left to a level of interpretation,
right,
the family or the guardian's request for information at various levels um, is something that still needs to be in the hands of the individual family guardian and needs to be in a way that is communicated in writing, and the ISP, PCPT are a place for that, and then holding the agency accountable and having a relationship with that agency
right,
that meets your needs, because some families, unlike you, are not as interested
right.
in a scrape or a
Well,
scratch.
it's kind of
It's
funny
all going to
because
vary.
I saw you could actually opt out of the notification. So it
Mhm.
made no sense to me. You can opt out, but
I
if you're
hear you.
opting out, it's a default, isn't you are notified. So it's like,
I hear you.
so
Absolutely.
it's just strange. Yeah, certainly I'll follow up and get that in the ISP, but it just seems like it shouldn't be necessary. And I think it probably would be better if the guardian's always notified and they can opt out, because you never know if an injury is caused something else. I don't think that people on online staff on-site staff can make that judgment.
Thanks, Mike.
Thank you.
Thank you. Dottie?
Yeah, Mike, I don't even know what to say because that seems to be such an obvious thing. If your person gets harmed, of course you'd want to know about it, and of course they should tell you. My my girl gets a bruise on her arm, and even though it's not a significant bruise, they immediately call me, and that's what should happen. I don't understand why there isn't a consistency in the way providers operate. Yeah, I just looked up um, the UIR grid to see what they need to inform guardians about, and that's a very big list, and that's not something that they can really expect families to understand. There should be a bottom default requirement that if your person is harmed, if there's blood, if you have to go to the hospital, um, they should be calling. I don't understand why that's not a thing. But the other thing that really needs to be cleared up is anything that, if you are a guardian, if there's anything that would affect or impede your ability to act as a guardian, if there is a medication error, if there is, um, uh, if, well, everything that you just described, if there's an injury, if there is a unusual financial incident that goes beyond what you already signed off on when you annually fill out those forms, that they need to tell you because it affects your ability to act as guardian. But I don't know where to put all this because I think, again, the state has to say very clearly to the providers, this is the um, basic subsistence level of communication that you have to have with your guardians.
Thank you,
That's all.
Bonnie. Denise Buzz?
Yes, I've been listening to everything that everyone has said, family member, guardian. I'm a family member and a guardian, and I'm looking at the screen here that talks about the needed reforms. And I just think, of course, there's an overly simplified solution that if all we hear about is that everything is person-centered planning, there's all these, webinars and workshops about person-centered planning. Person-centered planning would then simply mean the hierarchy is the individual's rights, the family member and guardian's rights, and everyone else. The providers are subservient to the individual and the family members. There shouldn't be this adversarial and defensive culture on the part of the state or approved providers when the rights of the individuals are guaranteed by federal law, by state law. None of this should be a problem, and yet it is.
Thank you. I know that we have concerns in our office when we get reports from individuals and families that the guardianship isn't being recognized by providers. So we certainly understand. Kate DeLuca?
Hi. I just wanted to add a quick thing, since there was a lot of talk going on about the law about connecting with families, but I also think too that it would be beneficial if that connection with other families was not mediated through providers. So if I wanted to request information under Stephen Comina's law for contact information, I'd have to go through the agency. And if there is kind of an adversarial relationship going on, they don't have to provide it to me, or they can say, oh, they didn't sign consent, and we wouldn't have any way to know. So I just wanted to offer that out there, potentially if that could be held by the support coordinator or something along those lines, that might be a better route to ensure that families can contact each other under that law versus relying on agency mediation.
Thanks. I think that that's a really good idea. I know that that was also a comment that someone had made, via the online form. I thought it was really interesting because we agree that certainly if the individual and family are having a dispute with the provider, that they wouldn't necessarily feel comfortable asking for that information from the provider. And next is John Brewer.
Good afternoon, all. Following up on, I think, the speaker just before Kate, wouldn't it be appropriate under needed reforms to simply say that providers must provide to guardians all information, including perhaps listing things like is it the MAR form filed, and any information that the guardians request, and that the guardianship status should include, in effect, I'm not sure how to put it, a waiver of HIPAA. In other words, if I am my daughter's guardian, I am entitled to get whatever medical information about her circumstances and condition as I would be to get my own information, because I'm getting it on her behalf. Could we make a more explicit statement under needed reforms, or are there too many bullet points in that box already?
I think many of the people who have been commenting all day long have talked about the fact that they feel the reforms are too broad and, certainly narrowing down and being a little bit more specific. So from the perspective of the report that we want to put out at the end, we're going to be collating all of the suggestions for that report.
Okay.
And I know
Okay.
I have not been able to really keep up with everything that is going on in the chat right now. So if we missed anything in the chat that needs to be addressed, be sure you could certainly repeat it in the chat and I'll try to get at it. Oh, Vincent.
Thank you. I guess I have a question. First, is there a component within the state, within DHS, or that is just for families it's like you're saying, separate from providers, separate from the other components. But and I guess I was thinking in earlier discussions, thinking along the lines of like a victim witness unit that exists in the criminal justice system, but to support families and victims and but it doesn't always have to be related to an abuse neglect incident, but just in general, a formalized way for families to be involved.
Sure. I think that that's a great question, and I'm not aware of it, but pivoting back to some comments that Paul Aronson made about the Justice Center during his talk, when he moderated the government role. One of the things that I found very interesting about that Justice Center model is that there is a family support unit in it. That family support unit happens to be headed by a family member. And the role of that family support unit is to be kind of the intermediary between the family and the investigation unit. So understanding that sometimes during some parts of an investigation, the investigator may not be able to speak with the family. That family support unit is the intermediary. They're the ones who can advocate, when the investigator can't necessarily speak to the family. So I think that that's a really great idea. It was one of the things about the Justice Center model that, as a family member myself, and working with families who contact our office, I think it's a really necessary component. So thank you for that comment. I think you and I are in agreement about that. And Dottie.
Yeah, I had to take a call a little while ago, but did we talk about parent training and the best way to get what you want? Unfortunately, there have been incidences where families go in with both guns going at once, and it doesn't work out with the way they would want it. I know there was an incident in my daughter's home where one of the moms came in and was ranting and just said, "Don't you understand? You work for me," and all sorts of like interesting things. But couldn't families benefit from, something, a handbook, an outline, something that helps them get what they want?
I think that that's a really great point. One of the things that does appear in the legislation for our office, if you've ever read it, is we're really here in part to help families with communication strategies. That said, we're an office of 5 people. We don't have the bandwidth, but that's like really core to the work that we do in our office. I would rather have a family member who's in a stressed out situation with a provider to come to us and work it out with us so that we can go back into those meetings as productive as possible. So I think that there's a tremendous need for it. And I think if there's a way that we can deliver that in a more broad way, I think that that's important. So no, I don't think we touched on that.
Yeah.
Dottie, I'm sorry, Dottie, but I do think that there's been many requests and conversations with the administration, DDD, about having a parent handbook and making providers responsible to share information about their organization, because we've already heard today, amongst all these conversations, that providers do things differently. And one might be meeting every month, one might offer a meeting every quarter. Maybe an agency doesn't offer any formal meetings. But how does the family, guardian, loved one know what that is, agency to agency? So I don't know how we've captured that here in terms of needed reforms, but I think that's something that we can maybe revisit if it's not already on this list,
Sure.
that there be some requirement for family communication, understanding the rules of the road in that organization.
Sure. Or even just simple negotiating tactics. If you've got a laundry list of things that you want changed, prioritize them and just go for the first three at any single meeting because that'll help you achieve something.
Mhm.
It might be just more doable.
Right. But, I'm sorry, I have to say this because I heard this earlier too, and somebody, was being limited on when they could go visit their child.
Mhm.
There are certain things that are just not permissible. And an agency putting a policy in place doesn't mean it's allowed. And how do you, as a family member, guardian, how are you equipped with that knowledge? Like what gives you that understanding? Because it's too many calls and interactions with families that I know I've had to say, no, they can't do that. An agency can't do that. Or the support coordinator has to call you monthly, has to check in monthly when they say, oh, I've only heard from them once a year. So how are families and guardians equipped with what their um, roles and responsibilities are, and before you can even question whether it's proper or not?
And I just want to point to a comment that Christina made in the chat. It's a question. Do the families get comprehensive training or guide on UIRs or their loved ones' rights?
They do not. They get lots to read, like we've all seen going into the chat today.
Okay. Kate DeLuca?
Hi, sorry, it's me again. Um, I don't know if this is just an idea that occurred to me. I don't know if it would be more apt to go under, the provider section or possibly even like government section. But I was just thinking that as a guardian, and what a lot of families are doing represents a huge amount of unpaid labor. And I'm not saying that, like we are doing it for our people. But I thought that it might be kind of an interesting approach when we're talking about provider accountability. If there was a mechanism for families to log how much time they are putting into elements that the agency is responsible for doing. For example, like under the CCP, we're not eligible to get paid for any time, and we're not asking, like, we're not looking to make a profit off of our situation. We just want to make sure our person is cared for well. But when we're spending 20 hours a week on elements that the provider should be doing, I think that it might be kind of an interesting way to levy a fine without it being a fine if essentially we are proving, hey, we have like X amount of time is not billable hours by the agency, like because the guardians are doing this. So I just want to, again, apologies, I don't know if it's the right section, but that was just something that had occurred to me.
Yeah, I think that's a really interesting point. Yeah, completely agree. Pat?
Yeah, I just keep going back to what Mercedes said. Like, I really think that that's a great idea, like some sort of cheat sheet almost for families on some of this stuff. Because again, I just entered this world 2 years ago, and the amount of learning that has to happen. And I learned one piece of information from this person, and then that person, and then that person. And how are families who really don't have time to do this kind of education, even understanding what the rights are? I mean, they're just going to believe it at validity. If an agency says, no, that's not our policy, they're going to say, okay, I guess I can't come see my son when I want to, I mean, I think it is critical that, maybe it's like the top 10, either federal regulations or what, those who've been in this space much longer than I have. And, Christine, your office is probably the best to put this together, but some sort of cheat sheet that families get right at the beginning of this, like, these are your rights. You know what I mean? This is what you're going to have to lobby for if you hear something opposite to this, because I've learned so much from all of you here, from Kathy, from people who've been doing this from so much longer. And even like, I just found out about this patient crisis handbook, I mean, that's available that, again, families don't know about. I mean, there's so much information there that it's easy to just be overwhelmed. And so it has to be short and sweet, but a cheat sheet of the top 10 most valuable pieces of information, I think would be amazing.
Thank you. I like that idea as well. We're a big fan of one sheets in our office, so we'll take a look at that. But I do think it's for the broader recommendations, that's also really important. I remember when I first came into the adult system, even working in this office, there were, many things that I wasn't aware of. So I really appreciate that. Just checking the chat. Yes, Gina notes that the council does have the quick guide to services, which if you're not aware of that, that is really helpful. It's almost like taking the policy and procedure manuals and really making them a brief, digestible guide. So Judy's asking a question, what are the agency requirements for BCBA in the group home with persons with high tier and acuity?
And Christine, Victoria also would like to speak.
Oh, okay. So Victoria, did you want to speak?
Yes, please. I wanted to make a comment about the comment about parents going in with both guns blazing, if I could. I don't know if that person is in a situation where they have had a family member in a home. It can happen to an elderly parent too, where your concerns are ignored or you're retaliated against when you have had concerns. But as a parent, legal guardian, and people that are kind of elderly and educated and been doing it for a long time, to be told how to behave by an agency and that there is a proper way to behave after you've been ignored or threatened or disrespected is, I think it's a little bit putting the cart before the horse. We are consumers of services that we have to oversee for people who may not, and in my case, cannot protect and speak for themselves. And so when situations get very not positive, you might lose your temper. For anyone to criticize a parent for their way of doing that is being in concert with the agencies who are trying to control you. Okay, so it is our responsibility to get very, very clear about what we want. What we're talking about here is being overwhelmed with information that nobody seems to be very clear about. Okay, it goes on and on. I have been listening all day. I have been doing this with my 34-year-old son since he was 3. My husband is a brilliant man. He has been doing it with me. We are still constantly being criticized for how we try to get the best situation for our son, who will probably outlive us. And for anyone here to insinuate that how a parent talks to people regarding this very important, the most important thing in our lives, is missing the point completely. That's what we're here for. We're here to say, no, when we were told that our son could no longer come to the home because he asked a question in a meeting, I had taped the meeting. The administrator who had the bad form of contacting me in an email, in a group email, telling me that my behavior and my son's behavior was inappropriate and unacceptable, okay, would not answer my phone calls. This is what we're talking about. That's the whole kind of crux of this. And then someone is going to tell me, oh, you know what? You need to learn how to talk to these people to get what you want. I don't really think so. I don't really think so. Like, I don't need to learn how to talk to the man I bought the car from to get a car that's going to work. I don't need to learn how to talk to the doctor to get the proper care. And if I don't get the proper care, there are very clear ways that I can ameliorate that situation. This is different. There needs to be respect coming from the agencies that do this sort of work toward the people that they are serving. And I am the legal guardian and mother. I really, really, really want to say to all the parents out there, I don't think any of you have ever gone into a situation with guns blazing when it wasn't, and for gosh sake, guns of all things, like but you don't start out that way. You do not start out that way. You start out putting your best foot forward on your best behavior for the person you love more than anything. And what ends up happening is your behavior is made personal and brought into question. You end up blaming yourself yet again for a situation that is beyond most of our ability to understand. That's all I wanted to say. Thank you, everybody.
Thank you, Victoria. Lisa, would you like to make a comment?
Yeah, I guess ultimately my son still is 23 and he still lives with me, and I'm hoping he does for an extremely long time. But I think one of the things I would really love to see is reforms that would allow an individual to stay at home as long as they can with supports that as parents age, we're faded out more slowly, where we're not told that we can't visit or that we're not that I think it's healthier for both the family, for the child, for the parents, and that it just seems to me that I was told by some people like, oh, if you don't put your son in a group home early, you're going to, it's going to be harder as they get older because he's going to be so used to living with you for so long. And then, but for me, and especially I hear all these stories, I hear the Miralax story and I can relate to that because my son has to take Miralax and it's prescribed. Like you're talking about putting somebody in a dangerous situation when really it should be made easier for if the parents want that child to stay at home, that child should be able to stay at home as long as possible, and there should be reforms to make that as easy as possible for the family, where they can get supports, where they can get nurses, where they can get behavioral supports. And you may think it's really not that easy to get right now. And especially if for me, in my situation where I have a medically fragile child and sometimes needs virtual supports and some of that stuff is not covered by DDD, then it's to me, all this stuff is heartbreaking because you see all these parents that want to do the best for their child and they get put into these situations where you become somebody that's helpless and you can't you can't do it. So I do think that for parents like myself who would want my son to stay here as long as possible, and not an inexpensive thing, and I understand it's a choice, but there should be reforms that can help make that more make that possible and make it a viable option for some of us. And as we age out, there can be people that can come in and maybe transform the family home into a place where they can live with him and another person or by himself in the future, but make it something like that more a viable option.
And I think that I appreciate all of those comments. And I think that part of the other advocacy areas on the blueprint, which I don't believe we're actually discussing today, but I think you're touching on the topics of succession planning as well as, other choices for housing, and again, understanding that as we all grow older, we do need, providers and other ways to be able to transition out of our homes and into safe environments. Kathy Freeman?
When we talk about power of providers and legalities, and someone's talking about medications, Paul was in my ISP meeting, it was a year or two ago, when the agency refused to follow a doctor's order. So, again, the power of the providers and what they want to do and not do. In this case, my son has a history of pica. It may not occur every day. He's smart enough not to do it in front of people. But I had a doctor's order for it. They assessed my son without getting my permission or letting me know. And I told them it was a waste of time because he's not going to do it well. BCBA or someone's there collecting data. Again, they didn't tell me about the assessment. And because of that assessment, they determined that they don't see the behavior. So therefore, they don't have to provide hourly checks as what the physician had prescribed. So I'm a nurse. I don't understand how that can supersede a medical order. And I don't honestly see how providers can change a medical order. And Paul's brought that out with his report when he shows crossed off times that they're supposed to be given. And again, that medication administration, people aren't aware there is a bill. It needs a couple amendments, like I said, with 24/7 health provider on call, and also that a nurse could oversee these things remotely. But it's a key thing that we need. And again, the power of the provider and the fact that they seem to think that basically no one can do anything what can we do? We can close them down or we restrict admissions. That's what has been done in the past. In my 15 years, I've seen that where, they'll restrict admissions, and that does hurt them in the pocketbook, particularly for those high need areas, which they charge a lot for the bed. But really, that's what we need to work on. Thanks.
Yeah. Do we have anyone else?
Christine, we have a question. I think it was in the chat earlier and now in the Q&A about what are the provider's agency requirements for BCBA? I don't know if someone wants to address that.
Yeah, I don't have the answer for that.
I think that the requirements stem from whether or not the individuals that are being supported require a BCBA. And then I would look to the new manuals that were just released.
Yes, I just found it. It was
Okay.
on page 20 of the supports manual.
Okay.
And if you have an acuity and there is a behavioral acuity, you need to provide BCBA services, and the qualifications are listed in that section. I think it's section 3.4 of the supports manual, but you're right, it is in the manual.
I just found it too, so it is in the manual, and I'll just put the reference in the chat here. Oh, too long. Can't put it in the chat. Sorry, it's too many words, but it is 3.4.2 in the manual. I hope that answers your question and can get you to more specific information. Pat has her hand up, Christine.
Yes, Pat.
And it is my understanding from providers that even with the behavioral component, that they are not, there's no line item to be charged for BCBAs. So I definitely, tell me what's the part of the manual, 3.42?
3.4.2, that's the requirement that if you have someone assessed with that level of need, then you have to provide that service.
Right.
And if there's an acuity, then the rate is enhanced. So that incorporates hiring a BCBA, or if somebody has a medical acuity, it might involve hiring a medical professional as part of the team, the plan for that individual. I think and one thing that we haven't talked about, and I'll raise it, there's anyone who has an acuity has something called an enhanced needs form, ENF, enhanced needs form. And that form kind of takes it a step further as I see it. I see it as you're identified as having an acuity, either medical or behavioral. And as a result, the agency needs to respond in a way that will detail what they will do to meet that medical or behavioral need. And they have to supply that to the support coordination. It is a required document addressing enhanced needs form. The agency has to fill that out, and as a guardian family member, you should be able to request and obtain a copy of that. And that is in and of itself kind of like the roadmap, the blueprint of what that agency will do to support that individual's need for acuity.
Yeah, I think the issue with the behaviorists, though, or the BCBAs, is that the rate in which they are reimbursing is nowhere near what it is in every other setting, educational, hospital, whatever. So I believe the new licensure is supposed to help adjust that, but I would like to see somewhere in this document that is looked at, just like every other licensed professional, OT, speech, there's a rate that's standard, and that there's never going to be BCBAs who take these roles on in the group homes or in the adult setting if the rates are less than half, which is what they are now, than any other environment in which they can work. And so I think that's the problem as well, as it may be called for, but it's very difficult to find anybody who will do it. And I've heard lots of pushback from lots of families saying that even though it's in the enhanced form, it's not getting done because they can't find it or they won't pay for it, or the agency says, well, there's no line item to bill for it. So those are the things that I've heard from our chapter.
Those are problems, Pat.
Yeah, and they're all real problems.
Those are problems. And so I put the rates, the standardizing rates in the state government section because I think that where that belongs. But if the provider is completing a form and signing and putting their name on it and saying what they're going to do, and then they turn around and verbally say, well, but we can't do this because we can't afford it, that's a major concern that needs to be raised.
That's a contract breach.
That's a total breach.
Sorry,
Dottie, you're next.
Sorry, I was just going to say that the other thing you can do is take it a step further. Take the language out of the addressing the enhanced needs form and put it right into the ISP, because sometimes that form gets lost. I know one of my agencies just said, oh, I can't find it. Just odd, but
But you're correct, Dottie. You can put anything you want to put in the ISP that's reasonable to the individual's needs. However, the agency has to say, in that form that they will do that or how they're going to do that. And every agency could change. So the enhanced need form might change based on the agency you're with. However, it's still a requirement that needs to be upheld. And as our disability rights partner put in the chat, it's also Medicaid fraud if it's a service that's being billed for and it's not being delivered. So keep that in mind. I see Mary Hurley and then Elizabeth Dalzell. And we have 3 minutes left in
I'm
this.
unmuting. This is a really big concern for me. Okay. The issue of the category of in the manual of a nurse and a BCBA. We keep using the terminology behavioral support. I understand that where there's a need for a BCBA and a behavior plan. But where is the component of mental illness? I mean, is it just me on the call that has an individual that has severe autism and mental illness? But there's no input here from, say, mental health professionals or from the START program that's here in the state or from NAD, the dual diagnosis organization. So it's really concerning to me today to hear the constant talk about BCBAs and behavior plans. It does not anyone here have someone who has mental illness, which requires a completely different regimen of services. So if that doesn't get put in to the blueprint, that it's a huge component, similar to someone who needs behavioral supports through a BCA and someone who has medical complexities. So it's a third category that needs to be addressed. I mean, even I was talking to someone at the START program, and he said that the best agencies in the children's services are those that have a BCBA and a therapist, a clinical psychologist. So it's like we're missing on the adult side the mental illness component. I mean, this is like a huge gap here. So I don't need to ring the alarm, but this is very, very, very concerning. Thank you.
All right. Elizabeth?
Regarding the enhanced needs form, since needs are constantly changing, would it be a good idea to put in our reforms that form is a quarterly form and it coincides with the face-to-face visits of support coordinators so that you don't go a whole year without that being updated?
I think that's a good idea. That makes sense.
I mean, there's no reason why it's not included in conversation during those quarterly meetings. I'm may not like what I'm going to say, but I just feel the need to say it. Unfortunately, I don't feel confident that the form and the process is being followed, period, let alone then bringing it in every 4 months. So Elizabeth, I agree that it should be an ongoing, just like the PCPT and the ISP are ongoing because needs change. And certainly if there's an enhanced need, there could be more reason why that need would change. But I think we can include a requirement for ongoing quarterly, but I'm really concerned that it's not happening. I saw somebody put in the chat, I never even heard of that. And that is my bigger concern.
And you can change your ISP at any time. I had one year in the beginning when Maddie when my girl moved into a home, that we changed our ISP 4 times. So you can change your addressing enhanced needs form. And I understand that some people are not following it. Some people don't even know it exists. But you can change the documents as often as you want.
With that, I think we're at time for this session. So we'll be taking a 5-minute, 4-minute break. and then reconvening on technology with Dottie, leading that conversation. Thank you, everyone.